Good morning. This is Hap May with the Legal Play.
Good morning, and I am Chelsea El-Azzi, Hap's associate. It's been a little bit since we've recorded one of these, so I'll see
Life is busy. But
oof, it has been busy. It has been busy. We've had hearings and mediations and all kinds of stuff taking up our time. But Hap and I were talking yesterday. If we were going to do a topic, if we were going to try to crunch one in, what would it be? And we came up with a good one. I think.
One that's been sort of what we've been doing the last few weeks in a couple of instances. So we thought we'd just roll that into a podcast.
Yeah. So Hap is a bit of an expert in this area.
A bit, yes, actually quite a bit lately.
Yeah. And man, it can be complicated. So I keep pushing the topic down the road. I'll go ahead and jump right in. Today we're talking about buying assets in bankruptcy,
Right.
assuming
Right.
property, whatever. If you're trying to get at some property and assets,
property or other assets, and the definition of assets can be broad. And we'll get into that in a minute. But sometimes you have a bankrupt entity, and there are all these creditors and all these liens, and it's hard just to prior to a bankruptcy just go out and buy it, because there's so many people have so many different claims and liens on a piece of property. It's kind of hard to sell it.
When you say prior to a bankruptcy, like you're saying even before an entity goes into bankruptcy, a business.
Yeah. Pretend for a minute we have a business that has a piece of property, and it owns the property, but it's got a first lien, it's got judgments against it, it's got tax liens against it, it's got
when you say property, we're talking about maybe a building.
Maybe a building. And it could be equipment, it could be other things too. But the easiest example is a piece of real property that has all these liens on it. You can't just go to the owner, the debtor, and say, I want to buy it, because there are all these other liens, and the creditors will each want a piece of it, and there's probably more. Typically in a bankruptcy situation, there are more creditors than there are values of the property to satisfy the creditors. So it becomes about fast forward, file bankruptcy. Either a Chapter 11, which kind of keeps the debtor in control and allows some court supervision as to how things are worked out, or a Chapter 7 where a trustee is appointed that will start liquidating assets. They have special powers in the bankruptcy code to sell things what they call free and clear.
You say they, the trustee?
The trustees, or in a Chapter 11, a debtor in possession.
Okay.
With court approval. They can sell things free and clear of liens. And what happens is, if there's a piece of property and the trustee wants to sell it, he sells it for a fair price, gets the money, and then all of the creditors who had liens on the property, their liens are now transferred to the proceeds the trustee gets from the sale. And the property is sold free and clear to a new purchaser, which is kind of where I come in, because I represent parties that want something in the way of an asset in a bankruptcy case. And we want to do a deal with the trustee or the debtor in possession so they can purchase that. Sometimes it's a piece of equipment or an asset. Could be things like copyrights, inventory, real property, claims, in a lawsuit. All these things that can be the broad definition of assets.
Yeah, and I will go into somewhat more detail on all of those things and ask them questions about that.
Yeah, can be sold, and there's a process. 363 of the bankruptcy code sets out the process. There's got to be court approval.
The bidding process.
The court can, in some cases, ask a bidding process and be an open bids. In other cases, particularly where there is an emergency or a need to act quickly, the court can act without having an auction. And what happens in that situation, we did one of these recently, was we made a proposal to the trustee. The trustee made a motion, set a hearing, gave parties opportunity to object, held a hearing, listened to the objections. The trustee overruled the objections and entered the sale without there being a bidding process.
Now, when you said there was some kind of like emergency, it needed to be done quickly, I feel like I know which case you're talking about, but that didn't involve like any, produce that might have like spoiled.
Well,
quickly.
that's
You used the bananas in the warehouse analogy
Yes,
before,
yes.
but in this case, it wasn't bananas in a warehouse. It was
No,
what emergencies
there
are you
were
talking
there
about?
were certain rights that the debtor would have lose if it did not pursue a particular piece of litigation. And there were some deadlines coming. So that's.
And this is you mentioned like assuming you can buy claims in a litigation. I mean, the one I know you're thinking of and the one I'm thinking of, it was a very, very complicated
Yes.
procedure
Yes.
to get all of these assets. And part of what was purchased was not only real property, but also
claims and litigation, some personal property that was located on the real property. And it was an opportunity to clean up a lot of things.
purchase a claim in litigation. Like in this case, it was.
Well, okay. Let me get that through. The debtor company had a lawsuit, and in this case, a judgment, and it had to pursue some other litigation in order to keep it going. So what was purchased was the debtor's rights in that particular piece of litigation
to pursue the judgment.
To pursue the judgment.
How do you value that? In order to like come up with a fair purchase price.
That's an art form. And we came up with a number and negotiated with the trustee. The trustee put it out there, for anybody to object to it. Nobody objected to the price. So it was approved. It was approved by the court. But that's it's a negotiation process subject to court approval and objection by the parties.
So even if somebody objects and the court is like, nah, I'd rather this be just cleaned up.
Right. And
I
usually
think it's better
and usually it happens like this. That I'm going to purchase an asset that's hard to value from the bankruptcy estate. Or maybe it's easy to value, but so I say I'm going to buy it for $10. The trustee says I'm agreeing to that if the court approves it. And somebody objects to that and say, no, that's not enough. Generally speaking, the court will say, if you're willing to pay more and commit to pay more now, I'll listen to your objection. But if you're just going to say that, the trustee should hang on to this and try to wait till the market turns around or some other magic buyer comes along in the process, we're not going to do that. I mean, we've got a buyer here today willing to pay money.
Yeah.
And so
the bankruptcy system is there for is efficiency in the process.
Yes.
To just let people clean things up, move
Yes.
things out, move on with our lives. And if there's someone here who's going to purchase it and do something with it, why let it sit around? Get it off my docket. Like
Right.
I've got other cases to
let
work
the
on.
trustee administer, liquidate it. Maybe doesn't get as much as it could if held on a long time, but I got creditors out there that need to get paid and administrative cost of keeping the bankruptcy going. So
okay, speaking of creditors that need to get paid, to circle back around to this analogy of a business that's got a building, some land, some equipment, maybe some other things, and there's like you said, mechanics liens, there's maybe mortgagers and other lenders and stuff. And you had mentioned that in some cases, the value of all of this might not be enough if you were to liquidate everything to pay off the creditors in full.
That's kind of why you went to the bankruptcy court. Yes.
Okay. So, and then if you still want to buy it, the debtor, this
and the you here is a third party, not the debtor, not the creditor, some third party that wants to buy it.
Yes. Okay. Fair enough. Keep my
yes.
pronouns
yes.
clean but in this case, once the debtor files bankruptcy and says, okay, here's everything that that the business that I own that's worth anything, here you go, trustee, do something with it. And the buyer who's had his eye on it, his or her eye on it, comes along and says, ooh, okay, well, hey, trustee, let's you and me make a deal. You said the buyer would be able to make a deal with the trustee, pay over some value. The trustee, I guess, would have to there's got to be a valuation process. And that can, like you said, that's kind of an art form depending on what it is.
Right.
Once they agree on a number, then you said the creditors rights transfer to that pot of money.
When they get closed, they agree upon a number, get a court approval, and close the deal.
Mm-hmm.
So now I've taken this
Real
piece of property and given the
equipment.
trustee $100,000.
Okay.
And let's say there were 500.
Way more than that, but it's usually way more than that.
So $1 million. You like it better. So I gave it $1 million, and let's pretend there were $5 million of liens on that property.
Yeah. Okay.
So you couldn't really do. It'd be very difficult to do a deal outside of bankruptcy, because you got different claimants, and you give them $1 million, and you have $5 million of claimants fighting over that. That you just hard to clear title on something like that. But in a bankruptcy scenario, $1 million. I mean, I pay the $1 million, and all of those $5 million claims now transfer, instead of being on the property, they're now on that $1 million the trustee has. And I mean, if the first lien has priority and can establish the fact that they have priority, they'll get all of it, or whatever the value of their first lien is.
So it doesn't get like divided up pro rata.
No, there's a whole priority that exists, in the property, and generally speaking, first filed.
Yeah, and I believe we've done a podcast on creditor priorities in bankruptcy and things like that.
Other than ad valorem taxes kind of come first, then the first mortgage, and the second mortgage, and if they're abstracts of judgments or tax liens or something like that, it's kind of who got there first, who got to the courthouse and filed their lien first. It's the general rule of how that works. So and sometimes there are disputes what's the balance of the first lien. There's some dispute as to whether payment was made. Sometimes statute of limitations run on something. Sometimes there's a defect in the way the liens are filed. So
whose job is it to figure all that out? Is that the trustee's job?
That's the bankruptcy court and processes, for them. But
I guess the attorneys for everybody.
Yes, those lawyers. Yes.
Okay. And actually, I think that falls often to the lawyers to find the defects in something.
Well, that's true.
This is why their argument fails.
Yeah. Yes. But so back to the kind of the business of that is that I represent people. In some cases, I have groups that I'm included in the investors that go buy a piece of property, or sometimes we buy mortgages. Sometimes what the debtor holds is a mortgage against another piece of property, and we buy that in the process. And it's sometimes if there's an emergency, sometimes you can negotiate it out without having a bid process. Generally speaking, the courts prefer a bid process. Bid processes can take any kind of form. They could be a live auction where everybody goes in a big room, and you have people holding up these paddles every time they increase their bid by $1,000. Or the way we did one recently where everybody had to make a proposal as to what they were buying. Then they had to put up a deposit for 10%. Then, the court or the trustee came up with a stalking horse, who came up with initial proposal and initial down payment. People had the opportunity to overbid that. In order to qualify to bid, you had to make a proposal and put a deposit. And so we did that. We overbid the original stalking horse.
And you define stalking horse. What is this?
Stalking horse is
like I'm
right. It's a horse racing analogy. Where stalking horse is the one that goes out first and kind of
sets the pace.
And that's what finding somebody who will make a proposal so that people can start saying, okay, this is what a proposal looks like. How much do I want to bid? Do I want to bid more than the stalking horse did? And then after that, other bids in the process. So we were qualified. Stalking horse was qualified because they put up their deposit, made a proposal. We made a proposal, overbidding that then set an auction for which we had in a conference room where only the qualified bidders, the stalking horse and my party, were bid, and we wound up being the high bidder with regard to that. And we are now in the process of buying the assets of this bankrupt business.
Okay, so. And in that case, I recall there being liabilities attached to.
There was some of the assets were free and clear, and others would have if we wanted to keep those assets, equipment leases.
Okay.
To assume the equipment lease or come up with some sort of arrangement with the equipment financer.
And if you're okay with it, I want to keep that equipment. Yeah, okay. I don't mind, assuming the lease or doing a new lease or something.
Right.
Fine. But in this case, there the buyer was like,
it's yet to be determined. I mean, we'll have discussions with the equipment leaser and they'll work out a deal or not.
There's a lot. Okay, so it sounds to me that there's a lot of steps in this process.
There is.
Depending on what it is you're buying.
Yes. And I mean, there are good deals to be found, but I mean, it's not as if this was free. I mean, you could get, some think that's worth $1 million for $1,000. That usually doesn't happen. But there's discounts to be had in the acquisition because the process calls for something to be sold fairly quickly.
Mm-hmm.
And in a limited time frame and in a limited market. It has some unique qualities to it that are different. You don't get to do a lot of due diligence. You do some. You don't get to do a lot of inspections. You can do some.
When you say due diligence, you're talking about like valuation and
valuation and
inspection of what you're actually buying.
Right. And
so you just kind of have to trust that.
Well, I mean,
the debtor and the trustee.
Well, and you don't. That's why you discount it. They give you a discount so it's efficient, so that if something is not perfect, you have a cushion there for which to cure whatever the problem is.
Who are the types of people that are like wanting to buy things in bankruptcy?
There are two. There are strategic players. I mean, I am in that business. I need those assets.
I'm in a similar business to the debtor, and I would love to have those things.
Or I want to get into that business, and the business has some inventory, some customers, some equipment, some property that would be useful to be cheaper for me to buy the assets of that business than to go out and start my own. So that's possible. Some other examples of strategic players is the guy who owns the property next door wants to expand, and his next door neighbor's bankrupt, so he goes in and makes a deal with the trustee to buy the land, so he can buy that. There are pure investor types, and they are looking for severe discounts and looking for properties they can flip. A lot of times you will get equipment brokers that make proposals.
Brokers, they'll like get the equipment.
Yeah, I mean, used equipment transaction people. Yeah, that will do that. Get a lot of those, and then they're looking for big discounts because they want to buy something for $5,000. Paint it and sell it for 10.
So you mentioned customers, and part of this is like intellectual property, goodwill, where this business that's going bankrupt has built up its reputation, has potentially a trade name, a trademark, and all of that. Can you purchase all of that?
Yes, you can do that. All that. You can mean trademark, trade names, customer lists, patents, things like that. I mean, one of the things that everybody knows that GM, maybe 15 years ago now, I'm trying to remember exactly when it was, filed bankruptcy, and it is a new company. It is not the old GM that was formed in 1900.
So they kept the logo. They kept the name.
No, they bought the logo. They bought the name. They bought the equipment, the assembly line.
But it's just a whole bunch of different people running it.
So they bought the name.
Well, they did a good job, because apparently I wasn't paying attention to that transaction, and I wouldn't have known the difference had you not said something. Now,
and there's some airlines that have done that too. Or bankrupt airline buys another bankrupt airline, and suddenly it's now United instead of Continental.
And I feel like Hap over here is salivating at the possibility of doing a deal that big.
Well, I mean, that's probably not going to happen, but I can do deals. Deal with bankruptcy and bankruptcy trustees in the courts in the process. And it is an interesting little niche in the law and in practice and the business in and of itself.
This has been an interesting discussion. I learned a lot.
Well, good. This is Hap May with the Legal Play.
All right. Thanks, Hap.